Section 29, Legal Hotline. Q&A, Part 6, Final Section. Today's Fair Housing Rules and Regulations, 2026 Standard. Introduction, bringing it all together in the real world. As we step into the final section of this course, everything we've covered, from fair housing laws and protected classes to assistive animals, advertising, disclosures, and HUD enforcement, comes together in one place: real-world decision-making. This final legal hotline Q&A is designed to test not just what you know, but how you apply it. This section ties directly back to Section 23, Disclosure, Section 19, Violations, and Section 26, HUD Complaint Process. Because in 2026, the biggest legal risks don't come from what you don't know, they come from how you handle situations in real time. This is where professionals separate themselves, not by memorizing rules, but by applying them correctly under pressure. Scenario 1, Subdivision Addendum Confusion. A seller owns a single parcel of vacant land within a subdivision and plans to sell it. The question arises, must the seller use the subdivision addendum? The answer is no. The subdivision addendum is intended for situations where the seller owns or has created 6 or more fractional interests in land. In this case, the seller owns only one parcel, so the addendum is not required. Additionally, AAR forms are not legally required in any transaction. They are tools, not mandates. 2026. Insight forms are not the law, compliance is. Scenario 2. Termite treatment discovered after inspection. Period. A buyer discovers after the inspection period that the seller previously treated the home for termites, even though the seller denied this in the SPDS. The buyer now wants out of the contract. Can they cancel? Yes. The seller has a duty to update the SPDS with accurate information. If the seller fails to do so, the buyer can issue a 3-day cure notice. If the seller does not correct the disclosure, the buyer can cancel and recover earnest money. Even if the seller corrects the disclosure, the buyer still has a 5-day window to cancel. This ties directly back to Section 23. Disclosure is ongoing, not a one-time event. Scenario 3, Boundary issue with a block wall. A seller informs the listing agent that the block wall sits 3 feet beyond the actual property boundary, making the lot appear larger than it legally is. The wall has been there for over 10 years. Does this need to be disclosed? Yes. Even if the seller may have a potential claim through adverse possession, the discrepancy between the legal description and the physical boundary is a material fact and must be disclosed to prospective buyers. 2026 rule. If it affects value, use, or ownership, it must be disclosed. Scenario 4. Affidavit of disclosure. Misunderstanding. An agent believes that an affidavit of disclosure is only required for vacant land. However, the property in question has a dwelling but is located in an unincorporated area and is not subdivided. Is the affidavit required? Yes. The requirement is based on the number of parcels, whether the land is subdivided, and its location, not whether the land is vacant. If the property meets the statutory criteria, the affidavit must be provided. This ties back to compliance. Assumptions lead to violations. Statutes provide answers. Scenario 5. Burglary. During escrow. During escrow, the seller's home is burglarized, but there is no damage to the property. Only personal items are stolen. Must this be disclosed? No. Under Arizona law, there is no obligation to disclose that a felony, such as burglary, occurred in the home. This falls under stigmatized property protections. This connects directly to Section 23. Not all negative events are material facts. Scenario 6. Sewer versus septic misrepresentation. After closing, a buyer discovers that the home is not connected to the sewer system, even though the seller believed it was and had been paying sewer bills. Is the seller liable? Probably not. The seller represented the information based on their knowledge, and the contract clearly places responsibility on the buyer to verify material items during the inspection period. Since the seller reasonably believed the information was correct, liability is unlikely. 2026. Insight knowledge matters. Intent matters. Verification matters. The pattern, where risk lives in real estate. At this point in the course, the pattern should be crystal clear. Risk occurs when disclosures are incomplete or outdated, assumptions replace verification, forms are used incorrectly, material facts are misunderstood. Protection occurs when information is updated continuously, material facts are disclosed properly, contracts are followed carefully, communication is clear and documented. This ties directly back to every section in this course, from fair housing laws to disclosure and enforcement. Bringing it all together, the final 2026 standard. As you complete this course, understand that fair housing compliance is not just about avoiding discrimination. It is about operating at a high level of professionalism in every aspect of a transaction. You are expected to understand the law, apply it consistently, communicate clearly, protect all parties involved. Because in 2026, the most successful real estate professionals are not just knowledgeable, they are disciplined, detail-oriented, and proactive in preventing problems before they arise. The final takeaway is simple. Every decision you make in a transaction has legal consequences, and your job is to make the right one. Online discussion. Question 1. Why is it important to continuously update disclosures during a transaction? Answer: because new information may arise that impacts the property, and failure to update disclosures can lead to contract cancellation or legal liability. Question 2. What determines whether something is a material fact? Answer: whether it affects the value, desirability, or use of the property. Question 3. Why is relying on assumptions risky in real estate transactions? Answer: because incorrect assumptions can lead to violations, legal disputes, and financial loss.